Very good morning to all my dear students. Today we are going to discuss about the drafting of an application to sue as an indigent person under the subject captioned as drafting, pleading and convention. My dear students and listeners, before starting with the today's topic, I just want to recapitulate the law relating to indigent persons as provided under the Code of Civil Procedure, which would be helpful for the better understanding of today's topic. My dear students, this particular topic falls under the unit number 4 of the aforementioned subject, that is drafting, pleading and convention. So my dear students, let's start with the law relating to indigent persons as contemplated under the Code of Civil Procedure. My dear students, as far as the word indigent suit is concerned, the same has not been defined under the Code of Civil Procedure. As you all are aware that various definitions and expressions have been defined under Section 2 of the said Act, but the legislature at that particular point of time, while drafting this Code of Civil Procedure, did not provide this definition. This indigent suit is also referred to as pauper suit. Further, the law relating to indigent person has been provided under Order 33 CPC, and Rule 1 tries to define pauper, and pauper is the individual who, without a support or a destitute person who relies upon help from public welfare funds or charity. The law regarding indigent suit or application to sue as an indigent person has been provided under Order 33 CPC, and its appeal therefrom has been provided under Order 44 of the Civil Procedure. As such, we have to read Order 33 and Order 44 conjointly. As far as the nature and the scope of Order 33 CPC is concerned, it enables the persons who are too poor to pay court fees and allows them to institute suit without payment of court fees. As far as the object of Order 33 CPC is concerned, the general rule is that at the time of the presentation of claim, it is the obligation of the plaintiff to pay the court fees. meaning thereby the provisions of Order 33 CPC are intended to enable indigent persons to institute and prosecute suit without payment of any court fees. Generally, a plaintiff suing in a court of law is bound to pay the court fees prescribed under the Court Fees Act, but a person who may be too poor to pay the requisite court fee, this order exempts such person from paying the court fee at the first instance and allows him to prosecute his suit in forma pauperis, provided he satisfied certain conditions laid down in this order, that is order number 33. Order 33 has been enacted to serve a triple purpose, that is to protect bona fide claims of an indigent person. Second, to safeguard the interest of revenue. Third, to protect defendant from harassment. Exception to the rule: poor are unable to pay the court fees at the time of the presentation of plaint. As such, Order 33 exempts such persons from paying the court fees at the first instance and allow him to prosecute his suit in a forma pauperis, provided certain conditions as laid down under Order 33 be satisfied. Order 33, my dear student, has been enacted to serve a threefold purpose, meaning thereby to protect bona fide claims of an indigent person. Second, to safeguard the interest of revenue. And third, to protect defendant from harassment. A person is an indigent person under Order 33 Rule 1 if he is not possessed of sufficient means to enable him to pay the fee prescribed by law for the plaintiff in such suit, or where no such fee is prescribed, when he is not entitled to property worth 1,000 rupees. In both these cases, my dear students, the property exempt from attachment in execution of a decree and the subject matter of the suit should be excluded. Further, any property acquired by the applicant after the presentation of the application for permission to sue as an indigent person and the decision thereon should also be taken into consideration for deciding the question whether the applicant is an indigent person or not. The word person includes a juristic person as well. This was so held in the case of Union Bank of India versus Khadar International Constructions, 2001, 5 SCC, page number 22. Now I would like to explain the meaning of sufficient means. Sufficient means ability or capacity of a person in ordinary course to raise money by available lawful means to pay court fees. Further, property exempted from attachment cannot be taken into account to calculate liability or ability of such indigent person, but the person's employment status, realizable assets, retirement benefits can be taken into account to determine whether a person is possessed of sufficient means to pay the court fees or not. So this is the most important part of our today's topic, or we may say this is the very or the point to be taken into considerations by a law student or by a lawyer or which may be kept or drafting an application to sue as an indigent person. So these are the contents of the applications to sue as an indigent person, and these are the particulars required in regard to the plaintiff in suit. Second, a schedule of any movable or immovable property belonging to the applicant with the estimated value thereof. Thirdly, signature and verification as provided under Order 6 Rule 14 and 15 of CPC. So from this, my dear students, we may infer that an application must contain the particulars of fact as well as law in regard to the plaintiff in suit must be there in this application. Further, the property possessed at the time of the filing of this particular application must also be mentioned by a law student while drafting an application to sue as an indigent person. Here, the property not only includes movable property but also includes immovable property. Further, it would also include tangible as well as intangible property. Next, the said application needs to be signed and as well as verified within the meaning of Order 6, Rule 14 and 15 of Code of Civil Procedure. Now, my dear student, next question which must be kept in mind. Applications to whom be presented and by whom, and when does this suit commence? This is the very important question which needs an answer for a better drafting with regard to application to sue as an indigent person. The application should be presented by the applicant to the court in person unless exempted by the court of law, meaning thereby this application would lie to the court which not only has the pecuniary jurisdiction but also have the territorial as well as subject matter jurisdiction, and it must be filed by a person or by an applicant who is exempted, who is not exempted to appear before such court. Second, where there are two or more plaintiffs, it can be presented by any one of them to that particular court of law which has the pecuniary subject matter and territorial jurisdiction as provided under the Code of Law, Code of Civil Procedure. Further, the suit commences from the moment an application to sue in forma paris is presented in the court of law. So, my dear students, before parting with today's topic, I just also want to explain it to you, the points which needs to be considered, that the application would also mention that there is a cause of action in favor of the applicant. Further, it would also state that the said application has not been filed or it has not been barred by law. Further, it must also state that the applicant has not entered into an agreement with the has not entered into an agreement with a stranger, thereby to finance the cost of the litigation. Further, it would also be stated in the application that the applicant within 2 months before the presentation of the application did not dispose of any property fraudulently or in order to get permission to sue as an indigent person. Further, it would also be stated in that application that the application has been framed and presented in the prescribed format of the as provided under the law. Further, it must also be stated that the applicant herein is suing as an indigent person. So my dear students, these are all the points which needs to be mentioned or needs to be kept in mind while drafting an application for or to sue as an indigent person. So this is all about today's topic. Hope you have learned a lot out of it. In case you are having any query, then you may write it to me at my email ID, that is rahularora.gn@jagannath.org. But before parting with today's lecture, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on drafting of an application under section 148A CPC. As you all are aware, section 148A CPC provides for caveat, meaning be aware, wherein the applicant directs the court not to take any action against him without opportunity of being heard to be provided to him in a suit or a suit which is going to be or which is about to be instituted against him by any party. So my dear students, I would like to request you to kindly go through the law once before the or to go through the law provided under section 148 for the better understanding of my second lecture. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe, and stay healthy. Thank you very much again.